Hello, everyone. Today I'm going to explain what the I-130 is. Many people have to fill out an I-130, so I wanted to clear up some misconceptions about what, as well as how to fill this out, why and when, and answer some frequently asked questions about it. My name is Raluca Hanea. In my law practice, I provide immigration, estate planning, and family law services to my clients in Lawrenceville, Georgia. Nina Clear, my marketing and office manager, is here with me. Thank you, as always, for all your likes, shares, and comments as they help others to see our videos.
So tell us, what is the I-130?
Okay, the I-130 is a petition you file with the immigration agency, and you file this petition to show the relationship you have with a person who is not a U.S. citizen or green card holder who wants to immigrate in the United States.
So it sounds like it's when you want to sponsor someone.
That's right.
Okay, and who would fill that out?
Either a lawful permanent resident, so a green card holder, or a U.S. citizen.
And does the person filing it need to live in the United States?
No, but there are only exceptional circumstances, such as being in active duty service member, that allow someone to file it overseas. Most of the time, that application must be filed here in the U.S.
And what does someone do if they are not in the United States when they file it?
They can apply for an exceptional circumstances allowance to file it overseas, but otherwise they must submit it via mail to the U.S. Chicago office of USCIS.
Okay, and I know that you said you would file this for a relative who wants to immigrate, but can you be more specific about who you would fill this out for? And first tell us if you're a U.S. citizen, because you said it was either a U.S. citizen or a green card holder. So if you're a U.S. citizen, who would you fill it out for?
Sure. So if you are a U.S. citizen, you will fill this out to start the immigration process for your spouse, unmarried children under 21 years of age, unmarried sons or daughters 21 years of age or older, married sons or daughter of any age, and brothers or sisters or parents as long as you are 21 or older.
Okay, and then what about if you are a green card holder?
If you are a green card holder, you will fill out an I-130 for your spouse, for an unmarried child under 21 years of age, and unmarried son or daughter 21 years of age or older.
So if you're a green card holder, you cannot apply for your parents?
Unfortunately, no.
And it sounds like you can't use it for married children if you're a green card holder either.
No, you can't.
What happens if your children are not married when you file the I-130 and then they get married?
If they get married before moving to the United States or before adjusting their status to a lawful permanent resident, then USCIS will deny or revoke their petition.
When you fill it out, do you list everyone on the same form?
No, you must fill out a separate form for each person unless they are derivative beneficiaries.
Okay, and what does that mean?
The beneficiary is a person you are filing to sponsor, and if they are the beneficiary's spouse or unmarried child under 21 years of old, then you don't need to fill out a separate form.
So the spouse or unmarried child under 21 would be the derivative beneficiary.
That's right.
Okay.
Mm-hmm.
And if the relative is called the beneficiary, what are you as the applicant called? The applicant?
No, you are called the petitioner or sponsor.
Okay. And then this is a question you get quite often. So you fill out the form and the child is under 21 when you fill it out, but it takes a while to be approved, so now they've turned 21, can they still come here as a derivative beneficiary?
And this is one of those answers where I have to say it depends.
Okay.
Because it really depends on the circumstances of your case. The Child Status Protection Act that was enacted in 2002 provides some protection for children who are derivative child beneficiaries who age out during the processing of the application. But in other cases, even though it may take years to process the application, the visas are granted based on the circumstances at the time they are processed. So you should always consult with an immigration attorney about your case.
Okay. And another frequently asked question is, I've filed the I-130, so how long till my spouse gets their green card?
Yes, people do ask this all the time. I think that is rather confusing to people. The I-130 is often filled out as a first step when applying for a green card, but its approval does not give a green card. What does it say? It says that yes, your relative, spouse, sibling, child, or parent can be approved to get a visa to come and stay in the United States. And now they will process the green card application.
So it doesn't even give them authority to be in the U.S., is what I'm hearing.
Yes, no,
Okay.
it doesn't.
And when you file for your spouse, you usually have to include another form, right?
That's right. You have to also submit it with an I-130A form.
Okay. And are there specific restrictions on filing for a spouse?
Yes, and this is based on your immigration history.
And what do you mean by that?
For example, if you gained your green card status or naturalization through marriage to a green card holder or a U.S. citizen, you may not be able to file an I-130. So you must review the instructions and might need to consult with an attorney to determine if you are eligible to file one.
Okay. And do you submit any documents with your I-130?
Yes, I always do. And you should too. Typically, if you're filing it for your spouse, you will submit documents that show that it is a bona fide marriage, as we have discussed in a few different videos.
Yeah, about what a bona fide marriage is, right?
Yes.
Okay, so if I'm understanding this correctly, filing the I-130, again, it does not give your spouse, parents, or siblings a green card.
No. You must file for a green card, usually at the same time, which is called concurrently filing. I'm tired. When the I-130 is received by USCIS, they give you a priority date, and your priority date is the date used by USCIS to process all other applications submitted for this particular beneficiary.
So if you concurrently filed an application for a green card, they would go by that priority date to process the green card application.
That's right.
Okay.
Yes.
And so they get the I-130 and they acknowledge it. So they send you a receipt saying we got it. And then what happens?
After they process it, you will receive an
official.
Yes, an official form from USCIS. It's called Form I-797
Okay.
C, and it's going to tell you if the I-130 was approved or denied.
Okay, and then once you get that official approval, what happens?
Well, it depends, again, on if the beneficiary is in the U.S. or outside U.S.
Okay, so will you explain what happens if they are here in the United States?
Okay, once the I-130 is approved, USCIS will start reviewing the green card application.
And do you need to send them anything to start the review of the green card application?
If you filed it concurrently with the Form I-130, USCIS will start reviewing the green card application on their own, and you don't have to do anything after that. Okay. If you didn't file it with the I-130, then you have to file the green card application after you receive the approval.
So you send the approval and the green card application
That's right.
kind of together?
Yes.
Okay. And what about if your spouse is outside the United States?
USCIS will forward the approval of the I-130 to the National Visa Center, who will begin coordinating the interview process at a local consulate that you filled out on your I-130 application. So this is when you will start the application for the green card. And we will talk more about this in a video tomorrow.
Okay, and I guess I should say not just spouse, but any relative outside the U.S.
That's right.
Kind of will go through the same process.
To the consulate process,
okay.
Yes.
And getting an I-130 approved does not mean you can buy your ticket and fly to the U.S. and you're not given the green card, right?
No, it only means that you are approved to apply for a green card.
Okay, and now to the most frequently all-important question, how long will it take?
Yes, how long will it take? We get this all the time. So we cannot give a definite answer to this, unfortunately. There are so many variables. It depends on if you as the petitioner are a U.S. citizen or a green card holder, as we talked earlier. Then you must determine what category of relative you apply for: immediate, which is a spouse and children under 21, or if it's a different relative where they fall in the family preference category. And then you must consider what country your relative lives in. And we talked about how long this could take and how to check in a different video. And we highly recommend you watch that as we give step-by-step instructions on how you can check. The category that gets the fastest approval is a U.S. citizen applying for their spouse or unmarried children under the age of 21 who are here in the U.S. This, in most cases, takes about a year. But please don't think this is any type of guarantee and will only take a year. I mean, each case is different and each processing center has different lengths of time it takes. If your relatives are not in the United States, surprisingly, the category that gets approved the fastest is green card holders applying for their spouses and their unmarried children under 21. And this takes about 2 years as well. And I say surprisingly because the applications that are made by U.S. citizens are by U.S. citizens for their unmarried sons and daughters, they take much longer than that. Thank you so much for watching today again, and we really, really appreciate everyone who watches and your likes and comments. And if you have any questions, please reach out to us as we are always here to help. Thank you and see you tomorrow.